चलो close your materials now. Materials notes, whatever you have, fast close it off. Let's start with formation of company. Quickly run through that. Formation of company under section number. Section number 3. Incorporation of company is under section number 7. Formation is under section number 3. It starts with the sentence, a company must be formed or may be formed. May be formed for a lawful purpose. For if you want to incorporate a private company, you must be having at least 2 persons, 2 or more persons. For a public company, you must be having 7 or more members. For an OPC, you will be having 1. That's the basic introduction of your formation of company done. Once the number of members have been segregated, we started discussing about the subscribers to memorandum. Can the company have shareholders before incorporation? When is the shareholders possible? Only when the company is incorporated. Only when the shares have been allotted, you'll become a shareholder. Before that, you'll have a process called as subscriber to memorandum. What do you mean by subscriber? A person who has signed. Signed which document? Memorandum of association. This signature is made to make a promise. He has purchased or agreed to purchase. Agreed to purchase when the company is incorporated. Today he has purchased or just agreed for it. When did the promise was made? Before incorporation. When will he become a shareholder? After incorporation. As of now, he is called as a subscriber to memorandum. For a private company, we must have at least how many members? Indirectly, we must have how many subscribers? 2. These 2 subscribers or the 7 subscribers for public company will go submit documents to the ROC or CRC. Give me the hierarchy of processes. Who is the ultimate authority or administrative body of Companies Act? MCA, Ministry of Corporate Affairs, has its head office in New Delhi. Can it alone manage everything in India? We have 27 lakh companies which are registered in India today. Can they manage everything on their own? So MCA divided India into how many? 7 regions. Each of the region was appointed with a head called as regional director. And this each region was again divided into parts, and each part was called as a jurisdiction, for which we appointed a person called as, don't use the word ROC, he's a registrar, and he used to maintain a book called as Register of Companies. But today the book is physical or electronic? Electronic. That's where the word comes from, Register of Companies. The registrar will maintain it. But this ROC has been removed from the powers of incorporation of company to make it centralized today. All the incorporation process today happening under Part A or Part B, reservation of name or submitting documents, happens with ROC or CRC. What is CRC? Central Registration Center, which is going to happen at a centralized level in Haryana, in Gurugram. So what's happening here? Who is submitting documents? The subscribers to memorandum are submitting documents to whom? CRC. How many documents were submitted in total? 7. What's the first document submitted? MOA and AOA. Quick run through. It is signed by one subscriber or all subscribers. But the CRC, after receiving the document, will verify, but verify only on a prima facie basis. There's a chance that there might be misstatements. There's also a chance that he might not be able to detect all the misstatements. Hence, we started that we'll have to make a promise. Give me technical word. We have to give a declaration. How many declarations were given? 2. The first declaration given by the experts, stating about documents or compliances, stating that all the compliances for incorporation of company have been complied. If at all they have not been complied, we'll not question the subscriber, we'll question the experts. Then second declaration was given by 2 people, subscriber to memorandum and first director. What do you mean by first director? Is the director? Give me basic answer, general answer. Director is always appointed by the share company with the help of the shareholders. But here, is the company already incorporated? But we need a director to start the business activities. The company is not yet incorporated. The first directors of the company are appointed by simply mentioning in the AO. If your name is mentioned in the AO as a director, you'll become a which director? First director. For all the subsequent directors who will appoint it, company with the help of the shareholders. These subscribers and first directors have given declaration regarding 3 things, stating that they are not convicted, stating that they are not guilty of a fraud, and all the documents they have submitted are correct. Once these three documents have been submitted, who starts verifying it? CRC. While verifying, he might have certain doubts about it. He might need certain clarification about it. He wants a point of communication, for which we are giving him temporary address or permanent address. Temporary address. What is our permanent address? Registered office. When is that established? After incorporation. As of now, I'll give you an address for correspondence until registered office is established. Then if at all they are satisfied, give me the details of people so that I can enter in my register. Particulars of subscribers to memorandum and particulars of. 7th point was something which is new for us. Will a director work for company's benefit or personal benefit? Company's benefit, that means he is always going to look for company's interest. But at the same point of time, he might also have personal interest involved. Can we deny the director from having personal interest? A director will have both the company interest as well as personal interest. He'll always work for the company's interest. But if at all he is put in a situation where his personal interest and company's interest are conflicting with each other, there's a chance that he might choose personal interest. Hence, in those particular transactions, I don't want him to participate. Can he vote? Can he speak about the transactions? No. Can he be still a director? Yes. Having interest in a company, having personal interest is allowed or prohibited? Allowed. But if you have personal interest, come and disclose it. That personal interest of the director has to be submitted to the CRC. How many documents have been submitted? 7. Submitted to whom? CRC. After verification, if CRC is satisfied about it, CRC will give you a document. Document called as Certificate of Incorporation. This Certificate of Incorporation will contain certain information in it. It will mention the date, it will mention the name of the company, it will mention the SIN number, it will mention your PAN. What is the name of the company? This happens under Part A or Part B. What have we done right now? Part B. Come to Part A now, which is happening under, again, all this is happening under SPICE Plus. What is SPICE? Simplified Proforma for Incorporating Company Electronically. SPICE was introduced in somewhere 2016 for the purpose of incorporating company, making it easy to incorporate a company. We have two parts in it. Part A and Part B. Part B talks about submitting documents. Part A talks about reservation or allotment. Reservation of name. Reservation of name. Start the process. You'll make a mistake. Be careful and answer. Reservation of name. Who will make application for reservation of name? Subscribers to? Only subscribers? Who can also make application? An existing company. Have both the logics very clear. Either application can be made by subscribers to memorandum for a proposed company, or application can also be made by a existing company for a change in its name. Application is again made to ROC or CRC. Either of them will go make application to the CRC. Once application is made, if this application has any defect, get the word clear, it is not false information, it has a defect. Will it be rejected completely? No. They'll ask you to resubmit it and giving you a time limit of how many days? 15 days. And obviously you have to pay fees along with this. Then CRC will verify. While verifying, CRC will keep in mind three categories, three concepts. The name of the company shall not be identical or too nearly resembling. Second point, the company's name shall not be offensive. Under which act? Any act. And the last category, it must not be undesirable. Undesirable means it is giving an impression that it is connected. Connected with whom? Either central government or state government or local authority. Then such name shall not be allowed. After verification, if it is satisfied, they will reserve. Reserve is temporary or permanent? Temporary for a period of how many days? You have to divide it both. For an proposed company, 20 days. For an existing company, 60 days. For a proposed company, I'll give you a time limit of 20 days in which you have to submit all the documents under Part B. This 20 days, can it be extended by payment of another 1,000 rupees as fees? If that 20 is not enough, can you extend it again for another 20 days, making a total of 60 days, but you have to pay how much? Or you can apply for a one-time extension of 40 days by directly paying 3,000. Once all the documents are satisfactory in nature, then name will be reserved or allotted, permanently given to you by mentioning that in the Certificate of Incorporation. This is all happening under Part. This topic is happening under Part A. Any doubts in this? Once the documents have been submitted, then we had the three logics we have to start now: cancellation or rectification or alteration. That's it, right? For formation of company, number of members, discuss that also. We'll close on the revision part. A public company must have how many members? Minimum of 7. Maximum of no limit. Minimum 7. If at any point of time the number of members have fallen below the minimum requirement, the company should be liquidated. The company will close the business. Is it actually a public company? No, it should have at least 7 to be called as a public company. Then company side states that I understand, I'll give you time. How much time is given to you? In this 6 months, what shall be done? You have to appoint another member to increase the number of members to 7. We have been given how much time? 6 months. In this 6 months, you are public company or deemed to be public company. If you are deemed to be public company, all the contracts which are entered in this 6 months period are entered in whose name? And we know this, separate legal entity, acts done by the company. Company itself is liable. Members are liable or not liable. But in this 6 months, if you have failed to increase the number of members, any transaction entered after 6 months, do we have this assumption of public company now? That means the contract is entered by company or the members. If the members are entering into contract with third party on a personal level, company is liable or members are liable? Members. Members' liability will be limited or unlimited? Unlimited, they will be personally liable. But we have to also remember, it's not all members that are liable. Only which member is liable? One technical word. Only members who are having cognate about it, who are aware that the number of members have fallen below minimum requirement. Remember, out of the 7 members we have, one of the member died. How many members were left? Out of the 6 members we had, only one of the member did not have knowledge about this process. Who will be held liable? 6 of them or 5 of them? Only 5 of them. Only 5 of them will be held liable. That's your section number 3A. That's what we have discussed yesterday. Continue with this process from here. Once these documents have been submitted for the reservation of name, come back to reservation of name, just give me clarity, we'll start each category. If the documents submitted are defective, get a very word clear, defective, you will be asked to resubmit. If the documents are false in nature, that means you have intentionally tried to bluff the Companies Act and given wrong information, incorrect information to the CRC. Is it your mistake? Defective, I'll understand you have made an unintentional mistake, I'll ask you to resubmit. But you have given a false information or incorrect information, you have made a mistake, try to understand the flow where we are. Once the documents have been submitted to CRC, the application you have made has a false information, incorrect information in it. If it has an incorrect information, start the process. Who will verify? CRC. Verify about those 3 points where the company's name is identical, resembling, offensive, undesirable. Once it is verified, name will be reserved or allotted. Reserved, who will reserve the name? CRC. Now the CRC, assuming, understand this logic, have reserved your name. Now I have multiple different scenarios. Try to understand each scenario separately. If while verifying it, the CRC got to know about the false information in the application. When did he get to know about the false information? While verifying it. That means the name is reserved or not reserved. Then what will happen? The application will be completely rejected. There won't be any reservation of name at all. Any doubts on this? Application, when did the CRC got to know? Imagine you as CRC. You got to know about the false information at what point of time? Before reservation or after reservation? Before reservation. If it is before reservation, will the application be accepted? Application will be resubmitted or rejected completely? Rejected. The fees you have already paid, will it be refunded? Don't expect fees from ROC back. It's only one-way traffic. You'll pay the fee, will it be refunded? Application is accepted, will the fee be refunded? Application is rejected, will the fee be refunded? Fees will never be refunded to you. But understand this, it will be rejected. Now second scenario, ROC verified it and the name got reserved. He could not find the false information at that point of time. But after name is reserved, the story is not ended. We still have time for the allotment. Now, how much time is given for a proposed company? How many days? ROC found out the false information during this period. Think about it. Is the name already reserved? But the company is not yet incorporated. Now what's going to happen? If the name is already reserved but the company is not incorporated, the reserved name will be cancelled. So cancel logic is used only when name is already reserved. If the name is not yet reserved, I'll simply use the word application has been rejected, not name, because you're not been given a name at all. Your application will be rejected. But if the name is already reserved but it is not, can I start using the word allotment is fine, this is correct answer, but in a different perspective, can I use the word company is incorporated? What do you mean by allotted? Company is getting incorporated, the certificate is given, you are existing company now. Start answering it in this sentences now. What happened? A subscriber to memorandum or an existing company made an to the CRC which is having false or incorrect information. But the CRC after verifying it have already reserved the name. After reserving the name but before company is incorporated, I got to know the false information. Give me the sentence. When did I get to know the false information? After name is reserved but before the company is incorporated. I got to know the false information. Will I take action? Now give me one word answer. Will I allot the name? I'll allot or cancel it. Name will be cancelled, that's all fine, but this person who submitted false information, I have to treat him a lesson. Otherwise they'll repeat the process again. Will they be punished? The person who made this application will be punished and the name reserved will be cancelled. Is this logic fine? And the last situation, the CRC got to know about it after incorporation. Give me the sentence. CRC got to know about the false information, yes or no? But when? After name is reserved and after the company is incorporated. If it is already incorporated, can I say it's also already doing business activities? But the document submitted was false. The name should not have been given at all. Because the documents were false, this name should not have been ever given at all. But who made a mistake? Don't blame it on CRC, you submitted false information. And we are not doing a conclusive evidence to blame it on CRC. We are doing a prima facie evidence. If CRC fails to verify this part, then I agree. CRC failed to do it. It is not subscriber's mistake. But if the document itself is falseful, whose mistake is it? Subscribers. Don't blame it on the CRC now. Once the company is already incorporated, try to understand it. Should this company be incorporated? Technically, it should not have been incorporated at all. But because of the fact that we are doing a prima facie evidence, we could not find the mistake in the document. Company got. If the company got incorporated, now you are the CRC. What shall we do with this company? What shall we do with this company? This company should not have been existing at all in the first place. What shall we do? You are the CRC. Answer whatever comes to your mind. You are the authority. You can do whatever you want. First, think. Correct? On the right path? Ask the company to wind up. Think about it. That is one of the options. Ask the company to wind up. But winding up the company is gonna not only affect the company but also creditors, but also employees, but also other businesses are affected. It is not only the company. Because of the subscriber's mistake, if I pass an order for winding up, it will have an impact not only on the subscriber but also everybody who is connected with it. And winding up a business is a loss for the Indian GDP. Winding up is one of the option, but I'll not go for winding up always. I have multiple other options available. Winding up is one option. I can wind up the company, or otherwise I can simply ask the company to change the name. That was the only problem I had. With your name, rest of all it was fine. Your name was a problem. I'll ask you to change your name. Who is asking all this? CRC after incorporation or before incorporation? Before incorporation process was similar. Very simple. Once the name is reserved but company is not incorporated, because company is not existing, I don't have to care about company. I'll have to care about only this reserved name. I'll simply cancel it. Cancel it and I'll impose punishment on the person who made this application. Now second category, when the name is reserved and the company is already incorporated, now I don't just have to deal with this person, I also have to deal with the company which is incorporated. First option is go for winding up. But is that the best option? Then ask the company to change the name. Change the name. Give me all options. Better remember in this same order if possible. Change the name. First option passed us. Change the name of the company. What's the first option we have? Who is passing on this order? For the purpose of cancellation of name, CRC is passing the first order they have. Change the name of the company. Be a little careful with this logic. Change the name of the company. Will it happen overnight? Because I am now a company, for change the name, I have to get my shareholders' consent by passing a special resolution. I have to conduct a general meeting. That means I have to call for a general meeting. I hope you guys know these procedures now. You have to conduct a general meeting. That means I have to send a notice of general meeting. Notice of general meeting itself is sent with a length of at least 21 clear days. But before I send this notice, I have to sit down and draft this notice first. It will take time to draft it. Before I draft it, I have to decide that I have to call for them. That means I have to first conduct a board meeting. To conduct board meeting, I have to send a notice of board meeting first. That's a huge process I have to follow just to get one approval. Give me the flow on a timeline basis. I'll send a notice of board meeting, conduct a board meeting, get an approval from the board of directors, then draft the notice of general meeting, send a notice of general meeting, wait for 21 days, conduct the general meeting, explain it to the shareholders, then get an approval from shareholders by passing a. It will take time. If it is going to take time, I'm not expecting you to do it within 1-2 days. I'll give you a time of 3 months to complete this process. Who is passing this order? CRC, asking this company to change its name within 3 months. You have been given sufficient time to complete this entire procedure and change your name. Usual answer, think about it, company's name. I'll probably discuss this in today's session itself, but have this clarity. We'll come back to this point in a bit. I have a little clarity to give before we start it. Name of the company. A lot of people get this wrong. Name of the company doesn't only mean the brand name of it. It has two varieties of names. One is basically your suffix attached to the company that is also part of your name. Don't get this wrongly interpreted. Suffix is not an addition. It is also part of your name of the company. Now, Reliance Industries Limited is the entire name of the company. What is the suffix of it? Limited. What's the brand name of the company? Reliance Industries. What's the entire name of the company? Reliance Industries Limited. If I use the word name of the company, don't always assume that it is only brand name, Mama. It's a combination of both brand name and the suffix. Name of the company will always learn it as two parts. It is brand name as well as suffix. You know this. Public company will have what suffix? Limited. Private company will have what suffix? Private limited. And along with the suffix, they'll choose their brand name for being projected in the market. Which is more important for me as a company? Brand name or suffix? Brand name. Suffix is not something which I have chosen. I've been given to it. Based on the type of company, I've been given suffix. Brand name. I'll select it. I'll choose it. That's what the reservation of name topic is. I'll select my own brand name regarding similar to my nature of business, similar to the brand I am, similar to the business I want to be. I'll select a brand name. Which will be important for customers? Brand name or suffix? Brand name. You go to a customer, I'll not use the word Reliance Industries Limited. I'll use the word Reliance. That's a brand name they want. The brand name is more important for a company. Can I say if the brand name is being changed, reputation is lost? Especially in the today's market, the reputation of a company is depending on its. How do you recognize the company? Company doesn't have a face to it. You recognize the company by its brand name. If the brand name of the company itself is changed, reputation, goodwill, lost for the company. Whenever you want to change your name of the company, you have to pass a special resolution. Which resolution? What do you mean by special resolution? How much percentage? More than or equal to 75%. A special resolution should be passed. But come back to this and observe it carefully. What is happening in this particular cancellation topic? Who passed an order? Now it is mandatory or optional? Mandatory to change the name. And out of the two resolutions which we have, which resolution is easy to obtain? Ordinary. Which resolution is difficult to obtain? Now if it is not voluntary in nature, it is mandatory order passed by CRC, I cannot expect the company to be very accepting this change. I cannot expect them to be passing a special resolution. They will reduce the concept down to ordinary. but give me a general answer. Whenever you want to change the name, concept should be which resolution should be passed? Special resolution. But this time it is not voluntarily being done. It is done by an order passed by the authority. Will they be ready to accept it? No. Hence, I want to just get approval, but I want to get approval not by passing a special resolution. They have brought it down to an ordinary. But this ordinary is a special case. Remember the original concept. Whenever you want change, you have to pass special resolution. But here, because it is mandatory, we will pass which resolution? Ordinary resolution. That's the first order that can be passed by CRC. But that's not the only order I can pass. I can pass an order for winding up of the company. Winding up of the company. Any doubts on these 2 points? Third category is interesting logic. What do you mean by winding up? What do you mean by winding up? Give me the meaning of winding up here. What's the meaning of winding up? Closing the company. What do you mean by closing company? It is not actually closing company. Closing company is nothing but liquidation. Liquidation is removing the company from the eyes of law, but what is winding up? If the company is liquidated, creditors are still existing, they'll get affected. What the logic is, we have to first settle all the liabilities. Once all the liabilities have been settled off, all the creditors have been satisfied, then you can remove the company from its existence. Liquidation is a process that happens only after you have conducted winding up. What happens first, winding up or liquidation? Can you liquidate the entity without winding up? You have to settle everything first. For the settlement of liabilities, I'll sell all the assets we have, and after selling the assets, you go settle all your liabilities. This process of settling your liabilities is called as winding up. After winding up is completed, then you'll go for liquidation. So always remember the topic. For liquidation to happen, what should happen first? Without winding up, can I go for liquidation? But not every winding up will lead into liquidation. Say assuming company has 2 types of businesses. One is assuming, give me any business activity. Cotton. We have 2 business activities. Assuming we are into, say, a restaurant, and give me one more. Give me one more business. Theater. Okay, a cinema theater. Sure. We have 2 businesses, same company, 2 diverse business activities, restaurant and a movie theater. Now what happened? Our restaurant was making huge amount of losses. Our movie theater was working in a huge profit. It was making exponential profits, but our restaurant business was making losses. Now give me the answer. Should I wind up the company? What shall I do? Wind up the restaurant business. Winding up doesn't always mean that company will go into liquidation. But if I use the word liquidation, that means the company has already gone into winding up. Every liquidation will have winding up, but not every winding up will lead into liquidation. There are situations where winding up will still continue the business. Forget about it. I'll wind up both the businesses. I'll start a new business. I don't want to liquidate. I want this brand name of the company existing. I want to start a new business. Can I do it? So not every winding up will go into liquidation, but every liquidation will have. But there are exceptions we'll discuss whenever the topic comes in. There are situations where we'll not wind up but liquidate. How and when we'll discuss it later. But come back to this. Winding up of a company is one of the options given. So we have to sell all the assets, settle all the liabilities. I want a little more detailed answer on it with the timelines also this time. Say name got reserved. Name got reserved. What's the date today? 24th. On 24th of February, the name got reserved. Fine. Once the name got reserved, if it is a proposed company, you will have how many days of time in your hand? 20 days. In this 20 days, you have to submit all the documents as per part. Then your name will be allotted. Assuming the name got allotted, you have submitted all documents and your name got allotted on 1st of March. When did the name got allotted? 1st of March. Start answering this. With the timelines, you have to think and you have to come to the conclusions. If the CRC got to know about the false information, on 27th of February, what will happen? Cancel the name, fees, company, incorporated or not incorporated. Person submitting application will be punished. Fine. ROC, CRC got to know about the false information 3 years later. After 3 years, they got to know about the false information. Start. Who is passing order? How many orders can they pass? 2. Either they can ask you to change the name within 3 months by passing a ordinary resolution, or simply ask you to wind up. But which is a better option of 2? Change the name. Now think about it again. Last question. They got to know about the false information on 2nd of March. Are there employees existing? Creditors? I've not even started my business. I just got the certificate and I'm happy that I got the certificate. I've not even started the business. Can I wind up the company? Yes. Which option is better this time? No. Not winding up. We have a different concept called as striking off of a name. Because there's no need of settling anything, there's no winding up process required, let me remove your name completely. What do you mean by striking off? I have my register, remember? Register of companies where I'll maintain your details. I'll strike your name off. Striking off a name is nothing but winding up itself, but because you don't have any liabilities, I'll directly strike off your name. There's no need of going into selling assets, settling liabilities, no procedure required. Which is a better option and an easier option? Striking off. If the company is already incorporated and have already done business, have already generated creditors, etc., then I'll have to go for winding up. Now this time the third option available is ROC states that, CRC logic states that I'll either go for winding up, or if the situation is allowing me, I'll directly strike off the name. How many options in total? 3. Who is passing this order? This logic is called as what? Cancellation of name. What is the concept called? Cancellation. Give me all clarity on cancellation. We'll move forward. Who made an application? Either subscribers or an existing company. But this application had defect or false information. Defect or false? False information. The name got reserved. After the name got reserved, we have 2 options. Either the company is incorporated or the company is not yet incorporated. If the name is reserved but the company is not incorporated, name will be cancelled, fees not refunded, company will not be incorporated, person submitting false information will be punished. But if the name is reserved and the company is also incorporated, then who will pass order? Who made a mistake? Subscribers to memorandum. Who will pass an order? CRC for cancellation of name in 3 categories. Either, what are the first option? Change the name within by passing a ordinary resolution. Original topic was special resolution. Second topic, winding up. But that winding up logic is not required if you have not even started the business. I'll go for strike off of a name. Is it fine? There is a concept called as what? Cancellation of name. Same process, slight variation to the same example. We made an application. Subscribers or the existing company made an application to whom? CRC. And this application this time had all true information in it. No false information, nothing. Everything was correctly submitted. We have genuinely submitted the right information to the CRC. Do you expect the subscribers to have knowledge about every single company's name in India? No. But who is expected to have this knowledge? CRC, they're maintaining centralized data. They should be having knowledge about every company in India. Now what happened here? The CRC, while they were verifying those 3 points, the CRC failed to verify those 3 logics. Whose failure? And the name got reserved, and subsequently name also got allotted. What happened? Name got reserved and allotted with whose mistake this time? Who was submitting documents correctly? The subscribers company was submitting document correctly, but whose mistake is it this time? CRC. Because of this allotted name, what happened? We got allotted with the name. Don't focus on the name, Mama, focus on the logics here. We got allotted with the name ABC, which is already existing with another company. Can I say the existing company will be affected? The existing company have been doing business ABC Limited for the last, say, assuming 20 years, they might have gained goodwill, reputation, brand image. And if I am getting incorporated today with this same name, I can misuse their name. Is a loss for which company? Existing company. Will they sit silent? No. Now what happened? If the company has been, give me the words carefully, if the company has been incorporated with an identical or too nearly resembling name to an existing company, it's a loss for the existing company. Is that sentence comfortable first? If a company is incorporated, already name has been allotted, company has been incorporated with what kind of name? A name which is identical or name which is too nearly resembles what? An existing company. Can the CRC come and show its authority now? We'll beat the CRC if he comes to our office now. Whose mistake? We have done the business. We also have put in efforts and created brand for this ABC. Now the CRC all of a sudden comes and states that you cannot use this name. I've made a mistake. Will we sit silent? Then CRC logic states that I've made a mistake. Then who will come and pass an order? Central government. Because CRC cannot show their face to us anymore. They have made a mistake in this process. Central government will come down. A concept called as rectification of name. Who tries to rectify? Because they have made a mistake, let's rectify our mistake. Whose mistake? Authority's mistake, CRC. Now the authority, higher authority CG wants to rectify it. What's the concept called as? Rectification of name. If a name of a company is identical or too nearly resembles with an existing company, the central government will pass an order. Now think about it. CRC had how many options to pass the order? 3. What are 3 options we had among? Change the name, wind up, or strike off. Can the central government come and pass an order for wind up? What mistake we have done for being wound up? Strike off the name. The only order central government can pass is change the name. I will linking the logics between them. CRC and central government. It was CRC's mistake. They can pass whatever they want. Sorry, if it was subscribers' mistake, CRC can pass whatever the order they want. But if it is the authority's mistake, they cannot come and simply ask us to wound up. They'll ask only one option. Change the name. Same copy pasted. Change the name within by passing an ordinary resolution. Again, this was forceful. This was mandatory. We were not voluntarily looking for change. We were forced to do it. Then the logic was reduced from SR to an OR. Ordinary resolution is enough to pass. So give me basics here. Who is passing order? Central government. Whose mistake? Have we submitted application with false information? Subscribers are innocent. Company was genuine. But who made a mistake? Then who will pass an order? By a concept called as cancellation or rectification. By passing only one option order, one order possible, that is change the name. Change the name within by passing an ordinary resolution. Any doubt until here? Now a little extension to it. The central government states that I'll pass an order if I am in the opinion that there is an identical or too nearly resembling name on a suo motu basis. What is suo motu? On their own. Without anybody disturbing or giving information to me. If I got to know about it, I'll myself pass an order. Nobody has to make an application to it. Are you understanding the word suo motu? On their own. Now, again. Fine. I'll explain. I hope you are understood. Otherwise, I'll explain the word suo motu. Is it fine? Fine, right? For public's benefit, central government sometimes takes action on their own by a concept called as suo motu, on their own. Now, second option is that who will make application? The new company or the as a new company, I'm actually happy. I'm enjoying the brand name of the existing company. Why would I make application? Who is making application? Existing company. Making application to the crying with the central government, sir, we have been working hard for the last 20 years to create a brand name and some random company got incorporated the same brand name. We are losing business of it. Who makes application? Existing company. But there's a small loophole here. Existing company, a small loophole here stating that this existing company can make application only when their brand name is a registered trademark. This is a mistake from company side. It is still existing. Company's brand name is not going to give you a exclusive right to use it unless you get register it as a trademark. So what's happening here? The company's brand name is given to you, stated as permanent, but somebody else can use it and you cannot restrict him. You're not having the exclusivity of that brand name. You have to get it registered as a trademark. What should be done, Amma? What should be the better option? As soon as you get company, you should also automatically get applied with trademark. But what's happening today in the market, you have to separately apply for a trademark. If you forget to apply for trademark, can you have this exclusive right? No. So who can make application to the central government? Only such company which has its brand name being registered as a trademark. The person in whose name, get the word clear, the person in whose name the trademark is registered is called as a owner, is called as a proprietor. That person can be even an artificial person. It can be an individual. I can get a trademark registered, or even the company can get a trademark registered. This can be a company as well. I'm getting the wordings clear, Amma. So add the logic in this. Who will make application? A proprietor. Don't use the word company also here. A proprietor of a registered trademark. A proprietor of registered trademark will go make application to the central government, requesting central government to pass an order on such company to change their name. Who is making application? Don't use the word existing company. We'll use the word proprietor. Spelling might be wrong. Spelling is wrong. Proprietor of what? Registered trademark will go make application to the, forget about application, central government can also pass order on so motor basis. When will the CG pass an order? If it is of the opinion that, if of the opinion that the company's name is identical or too nearly resembles which company? An existing company. Then they'll pass an order. How many types of orders can I pass? Only one. Order is to change the name of the company. Change the name of the company within 3 months by passing a ordinary resolution. Once you have changed the name, go inform it to the ROC. ROC will change your name in the registers. Change within 3 months by passing ordinary resolution. Then you'll go inform it to the ROC, the registrar, and they'll change their name in the register of companies. They'll make the changes. Once the name is changed, think about it. Originally, you got a certificate of incorporation with the name mentioned. Is that certificate any more useful? To get a new certificate, they'll provide you a new certificate of incorporation mentioning which name? The new name which you got. Start answering. A slight change in the process. Go to cancellation topic. Think about it. Carefully think about it. Take time. Cancellation. Whose mistake? Subscribers. Can the authorities rub it on us and put demand on us? Rectification. Whose mistake? Can they force us? But they're still passing order. What if I am very rigid about it? Sir, I don't want to change my name. I don't want to change my name. It's your mistake. Deal with it. It is not my mistake. Cancellation, I'll be a little suppressed. I'll change my name because I had made a mistake. They can demand, they can punish me. But under rectification, who are you to pass an order? You made a mistake. Deal with it yourself. I'm going to continue with the same name. I'm not going to change it. If the company is rigid about it, central government said that I'll give you 3 months of time. If you don't change the name, I'll allot a random name to you. I cannot let you continue with the same name. It's going to affect the business activities. If you change your name on yourself in 3 months, that's fine. If not, I'll allot you a random name and I'll inform it to the ROC. Let him give you a new certificate directly. Which is better? Change the name or let the CRC choose a name? Sorry, let the central government choose a name. At least if you change the name, you can choose your new name at least. You can have a selection of a name. But if the central government directly allots you a name, they'll give you a random allotment where will not be suitable for our business maybe. Which is better? Change it. But who can also pass order? Central government may directly give you a name after 3 months if you have not changed it on your own. Section number. This is all coming under section number 16. What is 16? Rectification of name. This logic of cancellation we have discussed, these three topics, these three orders passed. This cancellation is under section number 4. It is a continuation of section 4. I'll discuss it later. Section 4 talks about MOA. What is MOA? We have multiple clauses, remember? The first clause we have is, under the name clause, we have certain rules which talks about cancellation. It's a part of section 4 itself. And this cancellation, rectification comes under section number 16. Rectification of what? Name. Fine. What is left out? Alteration. We have done section 4, a part of section 4 which is cancellation. Now section number 16 which is a topic for rectification. Now what is left out here is alteration. I'm going in bits and pieces. We are not completed section 4 completely. 16 is done. 13 will have a part of it discussed now. Close your books. Just listen for this. Section 13. So listen. Section 13. Before we start with it, I want a little 5-10 minutes of background on it. Then we'll start with section 13. Understand it very, very clear. We'll start with section 4 back again. We'll have a small introduction of what is section 4. We'll come back to 13 in a bit. What is section 4? Memorandum of Association. Section 5 talks about articles of association. What is section 3? Section 7 talks about, but to incorporate, I have to draft 2 documents first. That's your section 4 and section 5. 4 and 5 complete those documents, then you can go incorporate the company in section 7. What is 4? MOA, Memorandum of Association, and section 5 talks about AOA, Articles of Association. These 2 documents combined together are nothing but all the rules and regulations of the company. The rules and regulations of the company have been divided into 2 different books, Memorandum and Articles. Sir, why 2 books? Why can't we keep it simple and have a single book for the entire rules and regulations? Why is it required to be drafted as 2 different books? What's the reason behind it? They have actually a proper reason behind it. There are 2 separate books drafted for particular reasons to it. So just imagine this. The memorandum, you have knowledge, so it should be easy for you to understand than the inter students. You have this Memorandum of Association. Does it have a name clause? You know the clauses, right? I'll take the assumption that you know the clause names at least, right? Name clause, registered office clause, capital clause, object clause, liability clause, subscription or association clause. Now, and nomination as well. Start discussing on each category. Name clause. I am a manufacturing business. Will I have name? I'm a trading business. Will I have name? I'm a service industry. Will I have name? I sell goods. Which will I have name? Which type of company or which nature of company will have name? Every company. Every company has its own name. Every company has its own registered office. Every company has liabilities. Every company has capital. But when you talk about the internal rules of the company, can I say it is very different from company to company? What is our business hours? 9 hours. 8 to 8 to 8 are our business hours. For a different organization, business hours will be different. If you don't come to the class at 8 o'clock, I mean, we are liberal in the first 4-5 days. We are very liberal in the first 4-5 days. Once we get comfortable, then you will be standing outside after 8-5. Joke kadam, very serious on that. 8-5 you'll be standing out. Okay. Certain rules are there. Will the rules be matching with other companies? Rules are different from company to company. Depending on the nature of the business, depending on the location you are, depending on the structure of the company, the rules and regulations which are followed internally will be different. Forget about nature of business. If you have the same kind of business also, 2 different companies might have different rules and regulations. An organization which is same into education might have different internal rules and regulations as compared to Lakshya. Are you getting the point? Internal rules and regulations are something which the Companies Act was very difficult to define it. I cannot sit and draft internal rules for every company out there. The Companies Act stated that I'll give you this document, you guys draft it. You draft your own internal rules and regulations. I cannot interfere and check for every company in India. But when it comes to this document, I'll impose my authorities. I know every company has these documents. I know every company has these rules and regulations. The Companies Act has more grip over which document, MOA, which is applicable to one company or every company. But when it comes to articles of association, the companies that gave this document to you, you guys decide what to mention in this. If you mention the company starts at 9 o'clock, company starts at 9 o'clock. If you mention company starts at 6, you'll start at 6. Internal rules and regulations are very subjective in nature, differs from company to company. I'll give it to you, you guys draft your own document. But when it comes to MOA, because the rules and regulations of MOA are very static for every company, I'll put rules and regulations in it. MOA is drafted by Companies Act. AOA is drafted by company. I'll draft my own AOA. Hence, the consequences of this document and MOA will also be different. If they're different, I want two different sections, two different documents. I'll impose rules and regulations more upon which document? MOA. I'll give a free hand in which document? AOA. I'll have more procedures set out in which document? MOA. I want MOA to be mandatory. AOA, whatever you mention is up to you. You add it, delete it, is all up to you. You don't have to get permissions from any authorities. But when it comes to MOA, if you're changing your entire structure of the business, there's a proper procedure to be followed. Section 4 talks about MOA. Section 5 talks about. Then this section 4, think about it. When is this MOA drafted? We have done this sentence already. When is this MOA drafted? Before incorporation, drafted by whom? Once it is drafted by subscribers, if the circumstances in which the company is doing business are changing, whether the rules should also change, can they make modification in this? That modification is technically called as alteration, that happens under section number 13. MOA is drafted as per section number 4, but it can be in the future altered as per section number 13. Similarly, AOA is drafted as per section number 5, but it can be altered in the future as per section number 14. Give me all 4 sections combined. MOA under section number 4, which can be altered under section number 13. AOA under section number 5, which can be altered under section number 14. Section 13 and 14, what are they? Section 13 talks about alteration of MOA. Section 14 talks about alteration of, what is MOA? What is MOA? Give me the definition. Memorandum means the memorandum of association. What is it? Memorandum means memorandum of association. Nice definition, right? As originally framed or altered from time to time. As originally framed. Originally framed by subscribers to memorandum when? Before incorporation, or altered from time to time. Whenever I require alteration, I'll make alteration. Who will make the alteration? When is this alteration happening? After. If it is after incorporation, do we have subscribers? No. After incorporation, who will alter it? Shareholders. Originally framed or altered from time to time. Copy it into AOA. What is the definition of AOA? Articles. Articles means the articles of association. As originally framed or altered from time to time. Can be altered under section number 14. This document, does the Companies Act even know what is mentioned in it? Does the Companies Act know what is mentioned in Articles of Association? Does the Companies Act know what is mentioned in this document? If you want to make any changes in this document, I know what is it mentioned in. I know what is mentioned in this document. I'll create a proper procedure on how to alter it. But coming to this, do I know what is mentioned in it? If I don't even know what is mentioned, can I give you instructions on how to alter? Simply pass in special resolution, your alteration is done. Because I don't even know what is mentioned in your book, I cannot put a step-by-step procedure for it. Pass what? Special resolution, your alteration is completed. But here, if you want to make alteration, I clearly know what is mentioned in this book. I'll give you a step-by-step procedure on how to make alterations. Now this memorandum of association, I'll come a little more detailed into this point later part. Just give me the names of all clauses, we'll close it off from here. I'll come back to this, we'll have discussion on these 6 clauses in a little more detail later. What are the 6 clauses we have? Fast run through. Name clause, registered office clause, object clause, capital clause, liability clause, and association clause. What are the categories we have? Name, we have registered office, we have object clause, we have a liability clause, capital, and association clause. And you can add the nomination clause as the 7th point if required. But that 7th point will be nomination mandatory only in case of OPC. I'll put it separately. Now let's forget OPC, discuss on the 6 points. On these 6 points, I hope you have basic knowledge of it. I'll go a little more detail later part. Name clause. Name, we have just discussed it. Name includes two things. Brand name and suffix. Can we wait for this to happen for maybe 15-20 minutes? Comfortable, fine? Can I complete this part first? I'll go detailed in this point. Let me complete all these clauses, then we'll come back to 13. It'll make a lot more sense that way. Name clause. Think about it, Emma. What is name clause? Name includes two things. What are the two things we have? Brand name as well as suffix. Suffix is given to us or chosen by us? Given. Given based on the type of a company. But but the brand name, we choose it. We choose it by making application to the CRC. Now, suffix. Let's come to the easy part first. Quick, Amma, you know these answers. A private company will have the suffix of private limited. A public company will have the suffix of limited. Can a section 8 company use the word private limited or limited? They are prohibited. They have been given a privilege to be called as a special category. They can use names such as trust, foundation, forum. Give me some more names. Charitable, club, society, etc. Give me 4-5 names, that should be sufficient. Then we have OPC. OPC is given again a special importance. Try to understand the word clear. OPC is also a private company or public company. Because the rules have to be reduced, I cannot take risk. It should be a private company. It is a private company. If it is a private company, what will be the suffix of it? Private limited will be there, but to segregate that it is an OPC, in the brackets I'll mention OPC. Or if you are not lazy, you can write one-person company. Private limited will be there. End of the day, I am a private company. With the private company, private limited, I'll also have the word OPC mentioned in it. Is it fine as of now? Now there comes the difficult parts from here. Not difficult part, I've actually given a hint of this already. Government company. What will be the suffix of a government company? It will have suffix. What is the suffix for a government company? I'll make it easy. Government company is a private company or a public company? Government company is a public company or a private company? We already discussed this. Government company is either a private company or public company. If in that company not less than 51% of paid up share capital is held by government, it is called as a government company. It can either be a private company or public company. So there are two possibilities from here. The government company, it can also be private or it can also be public. If the government company is private, easier, give me the easier answer otherwise. If the government company is public, what will be the suffix? Limited. If the government company is private, then the suffix will be private, limited. It will be still limited. It can be either private company or public company, but end of the day, they are working for whose benefit? Society's benefit. Government investing 51% shares. Government is getting money from where? They're printing money. How did the government get money? From the public. They collected taxes from us. The taxes collected by the government is used to fund this company. Indirectly, money is coming from where? Public at large. I'll still call it as which company? Government company. It may be private company, but it will still have the suffix of limited. A government company will always have a suffix of limited. That means I cannot identify by the suffix whether it is private or public. For identifying a government company whether it is private or public, I have to go through with articles. Articles and check how many clauses? 3. What are the 3? Give me the proper word. 3 restrictive clauses. If all 3 are existing, then it is called as. If any one of them is missing out, then it is called as public. But the suffix of a government company will always be limited, whether it is either a private company or even a public company. The suffix will always be limited. Your brand name and suffix. We'll come to the brand name in a bit. Registered office. People have wrong perceptions on this as well. Registered office. When is this document being drafted? Where are we? Section number? Section number. Or when is this being drafted? Before incorporation. Before incorporation, do we have a registered office? Have we established registered office? If you have not even established registered office, how can you mention the address of registered office? We don't mention the address of registered office. We don't mention the locality. We don't mention the city. We mention only the state in which the company is proposed to be incorporated. When is the company's registered office established? After incorporation. But when is this document being drafted? Before. At the time when I'm drafting this document, I myself don't know where my registered office is. How can I mention the address? Possible? I'll simply mention only the state in which the company is proposed to be incorporated. Say this is Telangana. In my registered office clause, I'll simply mention what? Telangana. I am going to incorporate my company in Telangana. Now, after incorporation, I've established my registered office in somewhere Hyderabad. Somewhere in the Hyderabad. Okay. Once I've established, if we have discussed this, can I shift my registered office from one place to another place? If I'm shifting my registered office from Hyderabad to Warangal, assuming, start the answers. Am I required to make any changes in this document? Is it still the same state? Will it require any modifications, or should I put the word? Will it require any alterations in the registered office clause? No. When is alteration required? When you're shifting from one state to another state. But when you're shifting within the same state, it's a concept simply called as change in the registered office. When you're shifting from one state to another state, I'll call it as alteration. If it is happening within the same state, you don't have to go make changes in your memorandum of association, but there's procedure to be followed, which is called as what? Change in the registered office. So what are the two categories we'll have? First and foremost, what is mentioned in the registered office? Are we going to mention the address? No, we're going to simply mention the state in which company is proposed to be incorporated. Once incorporated, can you shift your registered office? Can you close your registered office? Yes or no? Can you close it? Can you shift it? You can shift it from one place to another place. If it is within the same state, I'll call it as change. If it is from one state to another state, I'll call it as alteration. Then object clause. Object clause mentions the purpose for which the company is incorporated. The purpose for which company is incorporated. Can I change the purpose? Can I change the purpose for which company is incorporated? Yes, I can modify my objects of the company. I can start a new business. I can discontinue a business. Everything is allowed. I can change the business of the company. I can alter my object clause. It is allowed to alter it, but there are procedures to be followed. What procedures we'll discuss in a bit, but one word answer. Can I change the purpose of the company? But one thing you have to remember, whenever you change the purpose of the company, you should also make sure that the name of the company is not deceiving your customers. The name of the company should also be changed in such a manner that it is matching with your new objectives. What's the logic here? If the company changes its object clause, remember the name of the company is chosen in such a manner that it depicts my object. It is portraying my business. But if I change my object clause and have the same old name continued, there's a chance that the customers might be deceived. Then the law states that whenever there's a change in the object, there should also be a change in the name. Name clause, so that the new name will have a description about my new objectives. I have to change my name of the company. That's where the ITC got its name changed. ITC came into India in the year 1908 or something. 1910 it got incorporated. In India it was doing business of what? Tobacco first. Only tobacco. What is the full form of ITC? Indian Tobacco Company. It was tobacco company initially. Now today they are selling chips packet, tobacco in chips packet. No. They are into multiple other products now. Multiple other products, mainly FMCGs, hotels, etc. A lot of business have been there. It's a very diversified entity now. If I still use the word Indian Tobacco Company on a chips packet, giving correct impression or wrong impression? Whenever there's a change in the object, there should also be a change in the name. And they've changed the name, and today there's no full form for ITC. There's no full form for the word ITC. ITC, it's ITC itself. There's no name because they wanted to carry their brand name. The word ITC had a brand name, but the Indian Tobacco Company is giving a wrong impression. They changed their name to what? ITC. There's no full form for it today. What's the company's name? ITC Limited, that's it. There's no full form for it. ITC is the company's name. What was the original company's name? It was initially called as Imperial Tobacco Company. Then they got changed into Indian Tobacco Company. Now it is simply called as ITC. Same thing happened with HCL, Hindustan Computers Limited. Very huge company. HCL doesn't have a name today. It is into a lot more electronic gadgets, just a computer. HCL doesn't have a name today. One of the biggest Indian companies we have. HCL. What is HCL full form? No full form. That's the company's name today. What was it? Hindustan Computers Limited. Doesn't have a name today. Or NTPC is one of those examples. National Thermal Power Corporation doesn't have a name today. NTPC is the company's name today because they are not only into thermal energy now. Initially when it was established, it was only into thermal energy, but they have diversified into multiple other ways of generating energy now. They're not NTPs. There's no full form for it now. What's the company's name? NTPC. NTPC is the name. There's no full form for it. What was it called as? National Thermal Power Corporation. It was thermal power alone. Now we have modified it. We have not only thermal energy, hence they have changed their name, but they wanted to have the brand carried. So what's the name of NTPC today? NTPC. There's no full form. HCL, no full form. ITC, no full form. All these have been changed because they have changed their objects. Whenever there's a change in the object, there should also be a change in the name. And the change in the name, you have been given a time limit of 6 months to do so. How many months of time? 6 months to change your name as a company's object. Liability, we have already discussed this. Liability of companies always. Liability of the members is of two types. Either it can be limited, or if it is limited, there's again two options here. Limited by shares or limited by guarantee. As a shareholder, my liability can arise at what point of time? At any point of time. But as a guarantee holder, my liability arises only when the company goes into liquidation. That's your liability clause. Capital clause. It is an interesting topic. Company wants a huge amount of capital, huge amount of money to do its business activities. Try to understand these words clear. This is where the definition of share also comes from. So be careful with this. We have incorporated a company and we want money to start the business, right? We need a total of rupees 100 to start business. We'll keep the example simple. We'll slowly escalate it. We need rupees 100. Can you invest? We'll pool all the life savings we have. Can we invest? Yes. Can you invest in this? I want 100 rupees for business. Can you provide me 100? Yes, fine. I want 1000 rupees for the business. Fine. 10,000. 1 lakh. Just 10 lakhs. 10 lakhs, I can't even start a business properly. I need 1 crore at least. 1 crore for a very small business I can start. I need how much? 100 crores, sir? 10 crores. I need 100 crores to start the business. Check your pockets. Check your pockets. You should have 100. No. You might have it in bank account. No. Do we have 100 crores? Try to understand this. Companies doing business at a large scale. While they're doing business at a large scale, they need a huge amount of capital investment, and you're not expecting a single person to bring in that large amount of capital. Hence, the total capital requirement of the company, have been divided into small parts. They should be equal, Amma. I'm not patient enough to draw all that, but they should be equal parts. That each equal part is a proportionate in the capital of the company. What is mean by proportionate? They have decided to use the word share. Forget about the technical meaning of the word share. Give me the generalized dictionary meaning of the word share. It is a proportionate in something. I have a share in something. I have proportionate in something. Share capital. The total capital of the company is 100 crores, but I cannot expect 100 crores from a single person. I'll divide them into small parts, and each proportionate will be called as a share. The smallest part into which the capital of the company is divided is called as share. Now this share will be sold. It will be sold at rupees 10. Now you can purchase it. Because the capital amount was very huge in number, we have divided the capital into small parts. Each of the small proportionate of the capital is called as a share. Now that's where the definition comes from. Share means a share. Share means a, what do you mean by share here? Proportionate. Share means a proportionate. Share means a share in the share capital of the company. It actually has meaning to it. Share means a in the share capital of the company and includes a stock. We'll learn that later. But each small part is called as what? Share. Now what should be mentioned in this capital clause? I have to mention the total capital of the company. What capital? The total. I'll come with technical words in a bit. It's the total capital of the company. But will I require this entire 100 crores on day one? That's my ultimate vision, is to have a business with 100 crores of capital. But as of now, I'll not invest 100 crores on day one. Out of this 100 crores, I might start my business slow but expand it over a period of time. Initial stage, will I require entire 100? Just take a random guess. How much would we require? Just a random number. Maybe some 1 crore will I require maybe in the first phase of the business. So I'll not have entire 100 crores issued to the public at large or the investors. I'll issue only one. How much will be issued? Is it mandated that everybody should accept it? If people have agreed to purchase it, that's where I use the word they have subscribed it. How much have I issued? I hope you know these words, so I'll be a little quick on these logics. When it comes to the prospectus document, we are raising money. I'll issue the document prospectus. I'll issue with how much amount I want to raise? 1 crore. That's the reason it is called as issued capital. Prospectus is being issued. Once it is issued, people will send their application forms and try to purchase it. If they have agreed to purchase 1.5 crores, can I sell them 1.5? Yes? No. I've only agreed to sell how much? I'm in requirement of how much? 1. Why would I accept 1.5 and have idle cash with me? I'll accept only 1. This 1 crore is called as the purchased capital. They made application for purchase amounting to 1.5. But how much was purchased end of the day? 1. That 1 is called as subscribed capital. Or otherwise, they made applications only for 95 lakhs. I accepted the entire 95 lakhs because I was in requirement of 1. I've received how much? 95. I accepted 95. 95 is called as subscribed. How much was issued? How much was subscribed? But I'm not asking this entire 95 on day 1. Out of the 95, I've called only rupees 50 lakhs. 50 lakhs is called up capital. And you have paid only 40. 40 is called as paid up capital. Give me the all hierarchies. First we have how much? 1 crore called as issued capital. This 95 lakhs called as subscribed capital, and I have called only 50. It is called as called up. You have paid only 40, called as paid up. 4 options as of now. First, issued, subscribed, called, paid. Is it fine flow? You cannot change the hierarchy. It should be in the same order. Any doubts until here? But company is allowed to issue a maximum of this amount. This is called as nominal capital. I'll come with the word authorized in a bit more. Nominal capital. That's also correct. I'll come with it. Nominal capital. Why nominal capital? Why is it given nominal capital? It is only namesake on paper mention. Am I using this 100 CR? How much am I actually using today? 1. But how much is the intention, or how much is mentioned in the paper? That is actually put to use, or only for namesake? Nominal. Only for namesake. Nominal capital. That's the one word of this part. 100 crores called as nominal capital, or also called as authorized capital. I can issue a maximum of 100 crores. I'm authorized to issue a maximum of 100. That's the reason it is also called as authorized capital. So total 5 classifications of capital, same order. First point, authorized or nominal capital, then issued, nominal capital. It is only mentioned on paper or used practically. Which paper? Capital clause in the MOA. It is only mentioned in the paper, in the capital clause in the MOA for namesake. I'm not going to use it. I'm authorized to use it in the future if required. So what is mentioned in your capital clause? Start answering all of them. What's the first thing mentioned in the capital clause? Authorized capital. Or you can also call it as nominal capital. Namesake mentioned here, but I'm not going to use it. Authorized capital. This entire authorized capital of the company is divided into small parts. I have to mention the value of each part, the face value of each share. If I mention the face value of each share, can I also say the number of total shares to which it is divided into? 3 points mentioned in the capital clause. First point, authorized capital, value of each share, that is nothing but the face value, and the number of shares into which the capital is divided. Keep the numbers simple and answer. 100 crores of authorized capital, value of each share at 10, the total number of shares will be 10 crores. These are the 3 things mentioned in your capital clause. Authorized capital, give me the wordings. Authorized capital, value of each share, number of shares to which the capital is divided. On top of it, 1, 2, 3 points. Fourth point, to become a shareholder, the subscriber should agree to purchase. How many should he agree to purchase become shareholder? Even 1 is fine. Should it be only 1? Or should it be at least 1? We will in the fourth point mention the number of securities to be subscribed by the subscribers to memorandum, which shall be at least 1. So total how many points are mentioned? 4 points are mentioned in which clause? Capital clause. Association clause, an interesting topic. Association clause is nothing but the history of the company. History of the company, which states that these are the people who started the company, these are the particulars of the persons who started the company. Who started the company? Subscribers. I'll mention the particulars of the subscribers. I'll mention the name, details, etc. and number of shares subscribed. That's the reason it is also called as subscription clause, subscribers to memorandum clause or association clause. The people who are associated with the company from the beginning, they're called as association clause. I'll mention their particulars in it. Nomination, will keep it aside, we'll discuss it later. Now you have to do the analysis and give it to me. Out of the 6 clauses we have, let's discuss each point separately. Association clause. Apply your brain, someone, don't rush on it, don't shoot the answer out. Think an answer, don't have to rush on it. Association clause, can I change the association clause? Can I alter the association clause? Yes or no? India got independence on 15th August 19. What happened? 15th August? Are you still confused about the date or what? When did we get independence? Which date? 15th August 1947. I want holiday on 16th. Can I shift it? Can I alter it to 6? Can I change it? That's the history of India. I cannot modify it. What has happened has happened. I'll have to learn, or I'll have to accept whatever that has happened. That's the history of India. Association clause is a history of the company. I cannot change it. I cannot alter it. There's no possibility to alter it. It will stay static. Until the company goes in liquidation, or even after liquidation also, that will stay static. That's not going to change. It is not possible to alter it. So think about it. Section number 13 talks about alteration. But association clause, can it be altered? So section 13 does not talk about association clause. Section 4, when we are defining the entire memorandum, I'll have 6 clauses. But when I'm altering these clauses, will I have association in it? No. Next, capital clause. Can I alter the capital clause? Can I increase authorized capital? Can I increase the face value? Decrease the face value? Number of securities? You know, the subdivision of shares, consolidation of shares, increase the authorized capital, issue more capital, etc. Whatever we do, there's a chance that we will alter these numbers in the future. Yes, that's fine. Capital clause can be altered. So we are just defining out of the 6 clauses what can be altered and what cannot be altered. Association clause, can it be altered? No. What is it? It's not the topic that it cannot be altered. It's a topic that it is not possible to be altered. Capital clause, can it be altered? Yes. Then liability clause. Companies Act is very clear. You're not allowed to alter. You got incorporated with one kind of liability, you'll stay with that kind of liability till the company goes into liquidation. If you want to alter, change liability, liquidate and start a new company. If you started as a limited company, you'll stay as limited company. If you have started as an unlimited company, you'll stay as a unlimited company. Give me the word clear. Liability clause can be altered or not allowed to be altered? Not allowed. Association clause, not possible to be altered. Are we getting the difference between them? Liability is not allowed to be altered. Then Object clause. Can I change my objects? Yes. Registered office, can I shift from one place to another place? But if I'm calling it as alteration, if I shift it from one state to another state, I'll call it as alteration. Brand. Can I change the suffix? But can I change the brand name? I don't like the private limited suffix. Can I change it? No. I don't like the brand name I have. Can I change it? But so how many clauses can be altered? How many clauses can be altered? Of the 6 I have? 4. These 4 will be altered under section number. Section number? Section 13 talks about alteration of these 3 things. These 3 clauses. Alteration of capital clause is allowed but as a separate section under 61. Not under section 13. Get the logics very clear. How many clauses are there? Forget all the rush. Keep it simple. How many clauses are there? 6. Out of the 6, how many can be altered? Out of the 4, how many are altered under section 13? 3. For section number, for alteration of capital clause, we have given a separate dedicated section to it. Section number 61. 61 is not part of a syllabus. Just remember, alteration of capital clause is possible, but not under section number 13. If I ask the question, how many clauses can be altered? Your answer should be 4. If I ask the question, how many clauses can be altered under section 13? 3. What are only 3 clauses that can be altered? Name clause, registered office clause, and object clause can be altered under section number. But capital clause can also be altered, but under section number. You can forget 61, but section 13 talks about what's the heading of section 13? Not only alteration of name clause, it talks about alteration of MOA, which includes 3 alterations. Come back. What were we learning? We had to start this topic of alteration. Now give me the proper heading of section 13. What is section 13? Alteration of memorandum of association, out of which will have how many subpoints to it? 3. 3 or 4? How many alterations? How many alterations under section 13? What are 3 alterations we will have? Alteration of name, alteration of registered office clause, and alteration of object clause. Now what are we learning? One part of section 13. Are we getting clear with this? We are learning which part? Only one part. What is that part we'll learn now? Alteration of name clause. Once we are done with the rest of the 2 concepts, we'll come back to it. We have still concepts to discuss. We'll come back to this registered office and object clause later. Let's just complete the name clause category. Can we alter the name? Can we alter the name? If I'm talking about alteration of name clause, it happens under section number 13. What is section 13? Alteration of MOA, in which I'm trying to alter which part now? Name clause. All 3 of them have different logic. Somehow we're only under name clause right now. To alter the name clause, to alter the brand name, just imagine here, it is wrong answer, but just you have to imagine this way to understand the logics. Name of the company is divided into how many parts? What are the 2 parts we have? One is brand name we have, other is suffix. For the next 15 minutes of discussion, we'll assume that we are modifying, altering what? Brand. Only the brand name. Forget suffix. Brand name. Can you modify, can you alter the brand name? Yes, you can alter the brand name. But if your brand name is being altered, who will be the first person affected by this? The company itself. What do you mean by company itself indirectly? Shareholders. They'll lose their reputation. Whatever work they have put in for the last couple of years to build their brand, to build their reputation and goodwill in the market, all will be lost by making changes. So it is one of the biggest effect on the company. I cannot let it be changed directly by board of directors. You know these logics. Who has ultimate power over the company? Who has ultimate power? But they have been delegated to the. But some powers have been reserved by the. And this is one of them. I'll take care of it. But think and start the answer from the procedural and timeline basis. Whose idea is to change? Board of directors. Shareholders don't have an idea about the business at all. Whose idea was it from the beginning? Board of directors. Start the procedure for me very, very detailed, Amma. First, what will happen? It will be an idea of a single director. He'll propose it to the board of directors. Then the board of directors will sit together. They will discuss matters and they will first decide whether to change or not to change. Once they have decided, do they have power in their hands? Then they have to come get approval from the. So the process starts from one particular brain. Whose? Not board of directors. One director might have this idea. Start the process. Whose idea? A director. A director's idea where he'll propose it to all the. Then they have to discuss matters. That means they have to conduct for which they have to send a notice of board meeting. We'll have more discussions on this meetings process very detailed basis later. Notice of board meeting is sent. Notice of board meeting is obviously sent to one director, every director. Then directors will come and attend the board meeting. We'll discuss whether that change is required or not. If it is not even passed with board resolution, is this going to move forward? If the board of directors feel that there's a need to change the name of the company by passing which resolution? But do they have the power to do it on their own? Then they have to get approval from the shareholders. To get the approval from shareholders, to get the approval from shareholders, they have to conduct which meeting? General meeting. Then they'll conduct general meeting. In this general meeting, you should be able to answer, what resolution will I pass? Special or ordinary? Special resolution? What resolution will be passed? Special resolution or ordinary resolution? This is voluntary or mandatory? Alteration of name clause is voluntary or mandatory? I'm doing it on my own. Is it being forced by any authority? It is being done by the company's own intentions. You have to pass which resolution? A special resolution. Start the process again. Be careful with this. Whose idea? A board of director. They'll propose it to sender of conductor. Discuss matters between the and then pass a board resolution. It is approved by board of directors. Is it sufficient to do it? We have to get approval from conductor. Gentlemen, are you able to imagine this stuff? You have to live in this imagination to understand these logics. Now, once the general meeting is conducted, we'll propose it to the shareholders, explain it to the shareholders, then we'll pass special resolution. Once the special resolution is passed, we can start altering our name clause. The name clause can be altered after passing which resolution? Special resolution. If I had to put in one word answer, what should be there to pass alter my name clause? Special. But there's a lot of background that happens behind this special resolution. Special resolution is required to be passed. Now there's a small mistake and small problem in this. Try to understand logics. If the company has done a default in the past, and because of this default, their brand image will be affected. It will not promote, but it will demote their brand image in the market. If you have done a default in the market, if you have done a mistake in the market, the brand value will increase or decrease. If the brand value is decreasing, link the process, extension box. If the brand value is decreasing, your brand value is giving a negative energy to the company, will the customers come back? Creditors, banks, it will be difficult for you to do business. Now what happens, sir? I'm getting difficult to do business because I am being associated with a brand reputation, a wrong reputation in the market. Let me alter my name. I'll simply alter my name and I'll portray myself as a new company. Misusing this logic. If you have made a default and you change the name whenever you want it, that is giving a intention that do default, change your name. Nobody will recognize you. If nobody recognizes you, that means you can start building your brand name from scratch again. Even though your brand image and reputation in the market was negative, you can change your name and start the business again. It's a loss for the public, banks, customers. We are deceiving them. Allowed or not allowed? Same point. If the company has made no default, but to increase the availability or the recognition of the business, awareness of the brand name, I want to change a fancy name. I want to change on a voluntary basis. I have not made any defaults. Can I change it? When does a problem arise? When the company makes a default and wants to change the name, they are trying to hide something behind that name. I'll not allow it. So logic states that this special resolution, even though passed by shareholders, there's a chance that the shareholders themselves want to hide something in the company. I'll not allow it until the company has proven that there is no default. One word answer. Can the board of directors themselves change it? Can the shareholders change it themselves? No. Shareholders can change it only when the company has made default or no default. If there is default, can even that special resolution change your name? No. Alteration is allowed only with the passing of special resolution and also to prove that the company has not made any default. If there is default, alteration is allowed or not allowed? Continue with the same logic. If I go ask the company, have you made default? If I come ask you, have you copied in the weekend exams? Obviously, a fraud will say, I'm not a fraud. I'm not talking about you, Amma. Are you a fraud? Obviously, a fraud will say. Are you getting the logic? If I go ask the company itself, have you done a default? The company will obviously say, I am the most genuine company you will find in India. Will you believe it? Will you believe the company? No. I'll check it. Pass a special resolution. I'll check whether you have done a default or not. If I am satisfied that you have not done a default, then I'll allow you to alter your name. Start the process. Whose approval is required? Whose approval is required? Shareholders. Once the shareholders' approval is received, can I alter the name on my own? No. I have to prove that I have done no. But company will not prove it. Company will not pass a statement. The government states that I'll come verify it. Who will verify? Central government. And it has been delegated today, but concept is central government. So give me the logic here. To make alterations in your name clause, you have to first get approval from the shareholders. Then you have to get approval from the central government. Central government will give you approval only when central government is satisfied that there is no default. Then you can change your name. Two approvals I want. One, central government. If central government has to give you approval, first go make application. When will you make application? After passing the special resolution, you'll go make application to the central government requesting central government to give us an approval so that we can alter our name. For this application, once we have made this application, CG has to verify it. Is it fine? Who will verify it? Central government. Now try to understand the practical scenario, what's happening in this. This is outdated, Amma. This is outdated, but this is how the books are drafted. Central government, once application is in the hands of central government, they want to verify if the company has made any default or not. So for which the central government passes an order, requests the ROC to provide two documents back to the central government. Who is requesting? Who has to verify? But does the central government know about you as a company? There are lakhs of companies in India. How would the central government know about you? Central government says that I want to know about this company a little better, but who has detailed information about you as a company? ROC. So central government will request the ROC, ask the ROC to submit the financial statements and annual returns of this company. You know these two sections, 137 and 92. Which company has to file them? Every company. Which year should I file it? Every year. I should file it with the ROC. ROC has the entire background of my company. Then the ROC will submit this financial statements and annual returns to the central government. Once it is submitted to the central government is now in a position to verify it correctly. Start the flow again. I want a detailed answer, Amma. Which resolution is passed? Make an to the, what will happen at the back end? This is not the law. Back end, what happens? Central government will request them to submit. And now with these two documents, I can actually sit down and check whether you have made a default or not. If you have not made a default, what do you mean by not made a default? You have paid your deposits, debentures and interest on them on time. What are three categories? I'll check whether the company has paid deposits, debentures and interest on such deposits and debentures. Whether it has been paid on time. If it is been paid on time, can I say there is default or no default? When will it be considered as default? When the company has failed to pay. I'll give the negative sentence. When is it considered as default? When the company has failed to pay. Failed to pay what? Deposits or debentures or interest on such deposits or debentures. It is considered as a default. If it is default, will the CG give you approval? Think again. Last logic, last scenario. Central government requested the ROC. Request ROC stating that I want 2 documents. What are the 2 documents? So that the central government will verify these 2 documents and check whether the company has made a default. Check whether the company has paid or failed to pay. After checking these 2 documents, if I have come to the conclusion that the company has failed to pay, will I give you approval? Fine. So what books have been checked? Say assuming 2 books are there. Otherwise give me a book. There are 2 books I'll get. I'll get these 2 books from whom? ROC. Who am I? Central government. Got 2 books from the ROC. What are the 2 books I have? Say financial statements and the annual return. I'll verify both the documents. Once I've verified both the documents, I'll be able to identify if there is any failure to pay, if there is any default. Now what happened? I requested the ROC and ROC sent me not the documents by a note stating that, so this year the company has not even filed the financial statements, annual returns. Did I get the documents? If I have not got the documents, can I verify? Without verification, can I blindly give you approval? If you have not filed your financial statements, not filed your annual returns, there is a high chance that you're hiding something in the company. I'll assume that that itself is an default. When will the approval not be given? When the company fails to pay or when the company fails to file. If you have failed to file it, I'm not even in a position to verify. That means you have most probably have done a fraud, most probably done a default. I cannot blindly give you an approval. If you have failed to file the documents, then also approval will be accepted or rejected. Application will be accepted or rejected. Failed to file what? Financial statements and annual returns. Section numbers 137 and section number 92. Close it off. Who made application? Shareholders are. Shareholders will not make application. Company will make application. Or board of directors is better answer. Who is making application here? Board of directors, or you can call it as a company. Company making application to whom? Central government. Central government will verify, directly blindly approve it. Verify whether the company has made a default. If the company has made default, where the approval will be given? They have given a negative sentence. When is it considered as default? If the company has failed to pay or the company has failed to file. Expanded. Failed to pay what? Deposits or debentures or interest on the deposits or debentures. Or the company has failed to file. File what? Financial statements under section number 137 and annual returns under section number. If they have failed to file any of these documents, then they will be considered as defaulting, hence they will not get an approval. If there is no default, then they'll get. Once approval is received, have you changed the name? No. You just got a green signal from central government that you can change it. Now you have to actually change it by submitting documents to the. I hope you are able to conceptually understand it from here. Once you got the approval, think. Once you got the approval, can I say you have to now make an application to CRC, existing company, for reserving a name? This entire process will happen. Linking the logics. Where were we? Section number 13. Come back to reservation of name, part B, Spice Plus. Who is making application this time? Existing company for a change in its name. But this change in its name is happening only after getting approval from the central government. Then I'll make application to the CRC. While I'm making application to CRC, I have to also submit the order passed by the central government. Only then the application will move forward. Once the verification is done, name will be reserved, submit the required documents, then not part B, required documents, then you will be incorporated. Sorry, not incorporated, your name will be changed. You will get a certificate. So in a nutshell, what's gonna happen? Once you got this approval, you'll go make application to whom? Who is making application? Company to the CRC, and you will submit this application, order passed by the central government, approvals, etc. Then CRC will remove which name? Old name, and they'll enter your new name. Once the new name has been entered, they should also change the certificate. The certificate they gave you initially has which name to it? Old name. Can I use the same certificate? They'll give me a new certificate of incorporation, a fresh certificate of incorporation, and this fresh certificate of incorporation they have given will have which name? New name or old name? They'll provide me a fresh certificate of incorporation. This time it will have included with a new name. It will have a date into it. What do you mean by this date? The date on which company is incorporated. Company is already incorporated. Company is already existing. What is this date? The date, the effective date of the new name. The new name is effective from this date. The original certificate we had, that is the date of incorporation, the date on which company comes into existence. This will be the date on which the new name will be effective. If the date mentioned is, say, assuming, what's the date today? They have mentioned 24th of February on this certificate. That means till 23rd I should be using my old name. From 24th I'll be using my new name. The new name is effective from the date mentioned in the certificate of incorporation. This is your section number. Section number 13, only alteration of name. Any doubts in this alteration of name clause? Alteration, how many alterations are there? How many? 4, out of which we have altered 1, which is name clause. Section 13 covers how many? Out of which we have done only one of them, alteration of a name clause. Am I going in bits? I'm going in bits and pieces. Is it comfortable? Sure. I'm jumping from concept to concept here and there. We have done section 4, we jumped to section 16, we came back to section 4, section 5, then we have completed section 4 clauses, then we came back to section 13 now. We're jumping from places to places. Is it comfortable, Amma? Sure. Fine, right? We are not going to complete section 13. Let this topic of alteration of name clause sink in. Alteration of registered office clause and alteration of object clause are similar to this, but with slight modifications to them. I want your brains to completely sink in and accept this entire concept of name clause. Once it is fully comfortable, then I can make modifications for the registered office clause. Slight modifications will be there, but similar process, similar structure will be there. I'll have the same structure, but I want you guys to be accepting this information completely first. We'll put it on hold right now. We'll start with a separate, we'll put this on hold right now. We'll start with a separate small section. 2 clause 62 talks about OPC. Very, very important for exam perspective. 1-person company. I know this is there in your inter syllabus, but still very, very important for exam perspective. 1-person company. Will not have enough time to complete it fully now. We'll have the introduction done. Quick answers from your side first. OPC. What is OPC? 1-person company. What is 1-person company? How many members will be there? This 1-person company was a new concept introduced to encourage the sole proprietors to come under the business of company format of business, so that we can regulate them better and we can have better supervision over such kind of companies as well. Partnerships. I've already motivated them to come into corporate lifestyle with LLP. Only thing that's left out was sole proprietor, that was not being regulated. Then we had to introduce a new concept, OPC. But as a sole proprietor, will you have any rules and regulations? Formalities. Documents to be maintained. Accountability. Financial statements. Audit process. Nothing is required, but if you convert into company format of business, you'll have a lot of rules and regulations. Obviously, you as a OPC were not habituated, was not accustomed to these rules and regulations. Will you convert? No. Then the Companies Act had to bow down. Companies Act had to reduce its rules and regulations and state that fine, you convert into our company format of a business, I'll give you lot of exceptions and lot of privileges under Companies Act. More than half of sections are not even applicable to them. If I'm applying not even half of the sections, lot of exceptions have been given to them. Can they raise money from public? There should be which company then? Private. Private company has less rules or public company has less rules? Private company has less rules, but compared to private company, OPC states that I'll give you even lesser rules as compared to a private company. Now, nothing but we call this as in the industry, not in the company side, we call this as twin companies, OPC and small. Wherever you see an exception, 99% cases there would be OPC and small. And OPC and small company, why do we call them as twin companies? Whenever they appear in twins. Whenever there is an exception, if you have OPC, they'll always be also small. They are twin companies, they'll appear together whenever we go for exceptions. Every company, every logic of Companies Act is given. Lot of logics have been exempted for both OPC and small company. Now start with this. We have reduced your rules and regulations. If you have reduced the rules and regulations, your possibility of risk, possibility of frauds are high. But I'm still satisfied because you're raising money from not even identified persons, only one person. Not even identified person. You're not issuing securities. You're not raising securities. You're raising money only from one guy, the sole proprietor, the one member we have. Is there any risk involved in it? No. Let him do business. Let him do fraud, he'll suffer. Let him do wrongful activities, he'll suffer. I'll not care about it. But the major problem in this one person company was, we are a public company. We'll close off with this example. We are a public company, assuming we have a total of 1 lakh shareholders. How many? 1 lakh shareholders. If one shareholder dies, do we care? Do we care? Is the process going to still continue? Company is a perpetual succession entity, which it is perpetual. It is not going to close by the death of a member. If a particular member dies, will it affect the company's life? If out of the 1 lakh shareholders, one particular member died, if he dies, what will happen? Will the company's business be affected? But these shares held by this member will be transferred to his legal representatives. Now go to succession law a bit. As per the succession law, if a person dies, his properties will be transferred to his legal descendant. We call them as legal representative. Is a word given by Contract Act. It is technically called as legal heirs. Legal heir is a person who is having the legal right to receive the left behind of his predecessor. Legal heirs. But because under Contract Act we are representing a contract, we call them as legal representatives. They are representing a promise made. But actual topic is that they are called as what? Legal heirs. Now it will be transferred to their legal heir, legal representatives. Now try to answer this. Succession law states that it should be transferred to son or daughter. Both of them have equal rights. Both of them have equal rights. Son, daughter, everybody has equal rights in succession law. There's no specifications, there's no discrimination made. Everybody has equal right. Elder or younger, no discrimination. Again, everybody has equal rights. Elder, younger, male, female, doesn't matter at all. Everybody of the family has an equal right over the assets of a predecessor, assets of a deceased guy. Now try to understand it. The legal representative topic is very dispute process, where if there is no specific rule made, it can be transferred to any of the family member. There will always be dispute in the family members. If there is a dispute in the family member, will the company law solve your dispute? I'm not a civil court to solve your dispute. Fight it outside. Fight it outside and come to me, state that I am a member with a court's order, I'll accept it. I get in the logic. Company is not going to be concerned in your dispute. If you have a dispute, go to a civil court, solve your dispute. Say we have 3 legal representatives, and court passed an order on one legal representative. Come with this order, I'll remove the deceased person's name, I'll mention your name. But it is not my duty to check the legal representative's disputes. Are you getting the Companies Act logic here clear? I am not responsible to satisfy or resolve your disputes. Solve it outside the Companies Act. Come to me with the court's order, I'll satisfy it. But court's order, as soon as you heard the word court, it will take time. Maybe it took 3 years. Assuming it took 3 years to solve the dispute. In this 3 years, who is the member? Nobody. Deceased guy died. He died. He'll not come to the meeting. None of the 3 legal representatives have been given a legal right yet. Nobody was able to exercise the rights for a period of. But still Companies Act states that I'm okay with it because I have the rest of shareholders who will manage my business. Even though there is a dispute, even though the dispute will take time to resolve it, I don't care much because I have my other members who can tackle my business activities. But the problem arises if it is a one person company having only one shareholder, one member. This is not a public company now. This is slightly change the logic. Not 1 lakh shareholders, one shareholder, one member. If this member dies and there is a dispute in the court of law, what happens to the business? He is the only person who needs to manage the business and he died. If you have this dispute still running in the court of law, if it takes 3 years, what will happen to the business in those 3 years? Are there other members, other shareholders who can manage? No. This problem arises only in case of OPC. Then companies have brought a new logic. I don't want this dispute to exist. I want a clear-cut picture on who will get these shares. I don't want this dispute and court procedure to go on. I want a clear-cut picture. There's also this logic in succession law. We have this legal representative, and succession law states that there will be a chance of dispute in case of legal representatives. Hence, we'll give you a concept called as will paper. Heard about it in movies, right? Willnama, will paper. We'll write a will paper. Will paper is nothing but I'll mention which asset will go to which of my legal representative. That will paper under Companies Act is called as nomination. Companies Act states that if it is a one person company and the member dies and there is a legal representative existing, but if there is a legal representative existing, there is also chance of disputes. I cannot take risk in one person company. I don't want a dispute. I want the member to mention the name of one person who will become the member of the OPC on his death. Nomination clause. Nomination. Nominee. Is it mandatory or optional? Only in case of. Because of the problem existing, the nomination topic was made mandatory under OPC for a public company. Is nomination mandatory? Listen to the sentence. Can the member, a member may nominate? Allowed? But is it mandatory to nominate? No. I may nominate if I require so. But if I don't nominate also, is it still fine to have disputes? Fine. Because I have other members. But problem arises only when it is which company? OPC. Has only one member. If that member dies, I want the business to continue. For the business to continue, I don't want disputes existing. I want a clear person who will come and run the business. I want to mention the name of a person who will become the member in the event of death of the nominee. Or even if this member is the only person, this member has to bring in not only finance. This is slightly different from our regular interactions. As a shareholder, what should he bring to the business? Finance. Skill is usually brought in by the. But having only one member, he is now obliged to bring in what? Finance and skill. Finance and skill is required. I'll have more discussion in the next session. We're already out of time. This skill has to be brought in by the member. Fine. We'll close it off on that. We'll have more discussion. It'll take more time to complete the sentence. But is it fine now? Members have to bring in what? Finance and skill. Nomination is mandatory or optional? Now we'll complete section number to class 62 in the afternoon session. It will be very important for exam perspective. There are questions being asked. Any doubts until here? We'll end in the evening session. Thank you.